everyone. My name is Andy Fields. I am a partner at the Jeannie Harrison Law Firm and the chair of the BHBA's Employment Law section. I'm delighted to introduce our speakers for this afternoon, Noah Lebowitz, Katie Mola, and Wendy Musell. Noah Lebowitz brings nearly 3 decades of exclusive focus on employment law to his work as a mediator at Signature Resolution. With a career that spans plaintiff side litigation, arbitration, and 9 years as a judge pro tem for the San Francisco Superior Court. He co-founded Duckworth Peters Lebowitz Olivier LLP and has served as an adjunct professor at the UC Law San Francisco, a AAA arbitrator, and court-appointed discovery referee, earning recognition as a Northern California super lawyer since 2009 and a fellowship in the College of Labor and Employment Lawyers. Known for his direct, patient, and candid style, Noah draws on his deep understanding of the legal, emotional, and practical dimensions of workplace conflict to guide parties towards resolutions that are both practical and durable. Katie Mola is a Deputy General Counsel at PRISM, where she leads the Employment Practices Legal Advice Service. She is a trusted advisor to California public agencies on reasonable accommodations, leaves of absence, performance management, and compliance-driven policy development. Before joining PRISM, Katie served in senior legal roles at the California State Auditor and CalPERS. Katie has served on the executive committee of the California Lawyers Association's Labor and Employment Law section since 2021. She is currently the section's secretary and co-editor-in-chief of the Law Review and past chair of the Education and Public Sector Conference Committees. She is also named the author of the section's California Public Sector Employment Law publication. Last but not least, we have Wendy Musell, who is the founder of the law offices of Wendy Musell, PC. She has dedicated her career since 1999, holding employers accountable for civil rights violations, representing employees in matters ranging from wage theft and discrimination to whistleblower actions, with particular expertise in involving federal and public sector employees. A nationally recognized leader in employment law, she has earned honors including the Daily Journal's Top 75 Labor and Employment Lawyers in California, Top 100 Women Attorneys in California by Northern California's Super Lawyer magazine, and membership in the Fellows of the American Bar Foundation, a distinction limited to 1% of licensed attorneys. She also serves as a past president of the California Employment Lawyers Association and has been recognized for her legislative advocacy, pro bono work, and commitment to advancing workers' rights across the state and nation. I am very happy to turn this over to the speakers. You guys are in for a treat. Go ahead, Katie.
Great. Thank you very much. I'll go ahead and share my screen here. Okay, thank you very much, Andy, and thank you everyone for joining us today. We are here to talk about associational discrimination and accommodation. So with that, some intro slides that we don't need to go over now. I'm going to turn it over to Noah to kick us off with today's key question.
Thank you, Katie, and thanks for everyone for, excuse me, for joining us. So here, what we're talking about today, this is really the key question. It's going to take some time to get through, but this is really it. Does the FEHA require employers to engage in the interactive process and provide reasonable accommodation for an employee who does not themselves have a disability, but is associated with someone who does? So why does this issue matter? Well, we know, and it's pretty much undisputed, that the FEHA does prohibit associational discrimination. So when we talk about discrimination as distinct from reasonable accommodation or interactive process, what we're talking about is Government Code Section 12940, subsection A. The kind of standard "thou shalt not discriminate against, take adverse employment actions against people for the various listed characteristics, including disability." And included in that are these associational claims. There's no dispute about that. However, there is no published precedential case talking about whether or not there is, in fact, a duty to provide reasonable accommodation and engage in interactive process for these associational disability claims. what we see is that these types of claims are almost always brought in the context of caregiving responsibilities, where the employee needs an accommodation such as remote work, flexible scheduling, or reduced hours. And in a situation where either the FMLA or CFRA does not apply or their time banks have been exhausted.
Okay, so with that, we're going to start by talking about the ADA. And we need to talk about the ADA because although the bulk of our discussion today is going to be about the FEHA and cases interpreting the FEHA, this is a helpful starting point so we can highlight some of the differences between the ADA and the FEHA. So the ADA recognizes multiple separate but related concepts. There's disability discrimination, there's associational discrimination, and reasonable accommodation. So the ADA, like the FEHA, prohibits discrimination on the basis of a disability. It also separately prohibits discrimination against an employee based on their relationship with someone who has a disability, or the relationship or association with someone who has a disability. And then unlawful discrimination under the ADA also includes failing to accommodate the employee who has a disability. So looking at those obligations one at a time, another important distinction that between the ADA and the FEHA here is interactive process, right? We all know that under the FEHA, the duty to engage in the interactive process is a standalone obligation. This is not true under the ADA. It is not a standalone obligation. It certainly comes up. It's a concept that's talked about, and it's a means to an end under the ADA. So, duty to accommodate. So the federal courts have been pretty consistent on this issue, at least under Title I. 2 out of 3 panelists agree. You'll hear from the one who disagrees in a couple of slides here. But 2 out of 3 panelists agree that the federal courts have been pretty consistent that there is not a duty to accommodate the non-disabled employee based on their association with a person with a disability, at least under Title I of the ADA. The EEOC takes that same position. They've had this question and answer up on their website as long as I can remember. There's been this FAQ saying, is there a duty to accommodate the person who, based on their association with someone with a disability? And the EEOC's answer is no. And the ADA provides this framework for what an associational discrimination claim is, right? You can't discriminate against someone because they have a relationship with someone with a disability. So that would mean failing to hire, firing, failing to give a promotion. And kind of the typical concern that comes up is, that person is going to need a lot of time off because of their caregiving responsibilities, or maybe they won't be able to focus so much at work because of they're distracted at home by their caregiving responsibilities. That's kind of the classic associational discrimination claim. And under both the ADA and the FEHA, of course, that is prohibited. So before we move on to the FEHA, I'm going to turn it over to Wendy, though, to talk about why one panelist disagrees.
Well, I think that this is not a completely resolved issue. And the reason for that is there's a number of cases, and you see some of those on your screen here, the Cortez case and the Proctor case, which did rule that under Title II of the ADA, which covers governmental entities, but also includes employment, there is an associational disability claim under the ADA. And what these courts looked at was the broad remedial purposes of the ADA and the enforcement provisions and the implementing regulations. And as we'll see, as it relates to California's Fair Employment and Housing Act, which is the law that governs discrimination in employment, including disability accommodation issues in California, some of the same arguments could be made for the ADA. Now, I think this is an emerging issue, and there are cases under Title I which say the opposite, as Katie has indicated, but I think this is an area to watch. So the first thing we want to do is just give an overview of the Fair Employment and Housing Act, California's law that governs non-discrimination in employment. It does differ in certain ways from the ADA. But first, we start with the general proscription against discrimination, and that includes protected characteristics such as physical and mental disabilities. Both are explicitly covered under Cal Government Code 10A. And there's a definitional provision, and that definitional provision is found under Government Code Section 1292603. Actually, all of O is the definitional system, section, but 3 is the subsection that we're going to be talking about today. And this is key for the construction in these cases of how courts have looked at this. Either they've taken one position or another. You can guess as a plaintiff's attorney which one that I think is the right one, but in any event, under subsection 1292603, it indicates that protected characteristics definition is a perception that the person is associated with a person who has or is perceived to have any of those characteristics or a combination of those characteristics. And so the argument in how certain courts have looked at this is they've taken the definitional section under 12926 and read it into the other provisions of the FEHA having to do with reasonable accommodation and the duty to engage in the interactive process. Specifically, under Cal Government Code Section 12940M, requires employers to make reasonable accommodation for the known physical or mental disability of an applicant or an employee. And under 12940N, requires employers to engage in a timely, good faith, interactive process with the employer applicant to determine effective, reasonable accommodations. The FEHA, the Fair Employment and Housing Act, does have a separate cause of action, unlike the ADA, for failing to engage in good faith in the interactive process. So that can be a standalone claim, unlike under the ADA, where that claim is subsumed under the duty to reasonably accommodate. So that's one change. Additionally, the definition of disability is different under the Fair Employment and Housing Act versus the ADA. And I think this is important for how this, looking in the future, how these cases might be perceived. Under the Fair Employment and Housing Act, it's limits of major life activity, the definition of disability, whereas under the ADA, it substantially limits. California law, that's very broad. So there's going to be a very broad swath of medical conditions that are included under the definition of disability, which is something to remember when we're talking about how is this going to work out on the ground in the workplace. Additionally, under the preamble to Government Code 12920, it does state, as used in this part in connection with unlawful practices, unless a different meaning clearly appears from the context. So this, worker rights advocates have indicated that this indicates that there should be a broad approach, a remedial approach, and I think that's also consistent with the legislative history. And so really the fight here is whether there's a multiple characteristic definition, meaning do you use subsection O and look at that in conjunction with the duty to accommodate and duty to engage in the interactive process, or do you use a singular definition and looking at the duty to engage in the interactive process and the duty to accommodate singularly without considering the preamble and the definitional system? So that's where the fight is happening in these cases. Some of the key differences that we've talked about is arguably there is no duty under the Americans with Disabilities Act to prohibit associational discrimination, but arguably, excuse me, it does prohibit associational discrimination. So for example, if you are discriminated against because you have a family member who has a disability, that's covered. Whereas the duty to accommodate, you need time off of work in order to address the needs of a family member with a disability, for example. That is arguably not covered. Now, of course, we have those cases under Title II, which I think is an emerging area. And so I encourage plaintiffs' attorneys and worker rights advocates everywhere to keep pushing that envelope. But arguably, that is a differential under the ADA. Whereas the FEHA has broader statutory language, which has created this open question and the series of cases that we're going to be going over today.
All right. So with that,
All right.
Noah.
Thank you. So let's talk about the case that started all of this, the Castro Ramirez versus Dependable Highway Express case. So this was a 2016 case, and as you'll see, it spawned two different two similar but different opinions. So basic background facts. We have an employee, Mr. Castro Ramirez, who was hired on as a driver, as a delivery driver for the defendant. When he was hired, he put them on notice that his son requires often daily kidney dialysis treatment. He's waiting for a kidney transplant. And that he, Mr. Castro Ramirez, is the only one in the household who's trained how to use the machine, and therefore he needs to be home every evening, essentially, to be able to administer the dialysis for his son. So because of that, he requested that his shift be such that he is able to be home in the evening by a certain point in time. Like I said, he made this request when he was hired. There was no problem. They hired him on. Apparently, there's several start times throughout the day at this particular workplace. And he was always assigned to the earlier start time so that he could be home in the evening to administer the dialysis. This was great, worked for 3 years. No issues. There's no issues. There's no indication that there's any performance issues or anything else. And then we have what we see often, frankly, in disability cases, or you have a new supervisor come into the picture. This new supervisor, for reasons that are not explained in the cases, decides that he doesn't like this arrangement and starts to assign Mr. Castro Ramirez to shifts that start later and therefore end later into the evening. Mr. Castro Ramirez says, hey, I've got this issue, goes through the whole thing, says everybody knows about this. This has never been a problem. New supervisor says, no, this is the way it's going to be, essentially. And then finally assigns him to a shift that absolutely puts him at an end time that is too late, and he won't be able to be home in time to administer the dialysis for his son. He refuses the shift. Supervisor says, if you're refusing, that means you're refusing to work and you're terminated. So Mr. Castro Ramirez files a complaint, several different theories under FEHA, including both associational disability discrimination and failure to accommodate. The trial court granted a summary judgment motion filed by the employer, and Mr. Castro Ramirez appealed. So we go to the appeal. On appeal, what's important to know about the appeal is that for reasons that are not explained, or I guess not necessarily relevant, Mr. Castro Ramirez did not pursue the argument and the theory for failure to accommodate on appeal, and essentially abandoned that theory. Instead, only pursuing the associational disability discrimination claim. Regardless, the court issued its first opinion in April of 2016. It noted very early on in the discussion that, in fact, the plaintiff had abandoned the the accommodation claim, but observed that that the question of accommodation is intertwined with the question of discrimination, and therefore it was relevant to answer the question: does the FEHA require and have it express a duty of employers to provide these reasonable accommodations and engage in the interactive process? in the accommodation situation, and they expressly held, the majority expressly held, it does. And to reach that conclusion, what the court did was, or I should say the majority did, was evaluated what Wendy was talking about before, the difference between, or the incorporation of Section 129260 into the unlawful practices section of 12940. And in particular, what the court observed was that the way the language of 129260 read and still reads is that disability includes the definition of disability includes the association with the person with a disability. In other words, as the court expressly held, an association with a physically disabled person is itself a disability. And based on that outcome of that reading of the statute, the court, or the majority, reasoned that the use of the singular physical disability and mental disability within 12940M and 12940N included an employee in this situation, because that employee, for status purposes, under the definition of 12926, themselves would be considered to have the disability, even though in reality they did not. And so based on that reading of the statute, the majority held that, in fact, the duty exists. Now, this majority opinion garnered a very illustrative, I should say, dissent by Justice Grimes, who delved into some Star Trek allusions and talking about going where no court has ever gone before, and how she believed this was something for the legislature to latch onto instead. And Justice Grimes in the dissent explained that in the employer's argument, which relied exclusively or primarily on ADA cases that had ruled that there was no duty in these situations, that those cases should be given a lot of weight in this decision and in this determination, and that despite the structural differences between the ADA and FEHA, that those cases and the reasoning should be adopted, and therefore would dissent from the case. Now, those of us who were practicing in that time period will remember that this case caused quite the stir. Listservs blew up, so to speak. Lots of management side firms' advisory newsletters went out with screaming headlines about this case. All kinds of activities were scheduled and seminars and whatnot. But all that was put on hold just 6 or 8 weeks later when the court issued its decision to grant the petition for rehearing. And then took the case back and issued a second opinion in August of 2016, vacating the first opinion, and expressly acknowledging, yeah, okay, we get it. The plaintiff abandoned this claim, so really it's not before us. So we're not going to hold expressly that there is this duty. But the court observed, and this is a quote, observed, quote, that the accommodation issue is not settled and that it appears significantly intertwined with the statutory prohibition against disability discrimination, and therefore said, well, so we still have to look at it. And then they went through the same reasoning and ended up holding that Government Code 12940 subsection M may, quote, reasonably be interpreted to require accommodation based on an employee's association with a physically disabled person. So that's essentially what they held, although, of course, it was dicta. Justice Grimes was not satisfied with what she essentially called logical gymnastics, and by the majority, and again, dissent.
All right. So after Castro came out, we get a smattering of cases with very inconsistent results where other courts are grappling with this issue. So the first one, another Castro case, not to be confused with Castro Ramirez. This is Castro versus Classy. This is an unpublished decision out of the Southern District of California from March of 2020. And in this case, the employee requested a reasonable accommodation of remote work due to caretaking needs of her newborn son who had a disability. So not surprisingly, the argument in this case was about individual characteristic definition versus multiple characteristic definition. That's kind of always the argument when we're talking about this. And in this case, the court rejected the argument. They observed that none of the sections in section 12940 contain the phrase associational discrimination, and concluded that 12940 M and N, which recall are about reasonable accommodation and duty to engage, are equally as subject to the same broad definition as the other subsections found in 12940, and on that basis denied the employer's motion to dismiss. I do think it's important to note that they certainly did not conclude that there was a failure to accommodate here. They just said that there was enough to proceed past the motion to dismiss phase.
Then there was the Monterosso case, and this is an interesting one. It's an unpublished case. It's from the Court of Appeal. The original case was out of LA. And in this case, the employee had filed the complaint in that he had asserted a number of causes of action. Many of them were kicked out at summary judgment, including punitive damages, failure, the duty to prevent was kicked out, among some other claims. What was left, however, was a CFRA claim, California Family Rights Act claim, as well as an associational disability claim. And those went to trial. So the facts were that the employee learned that his mother had suffered from a stroke. She lived out of the country. He obtained authorization in advance from his employer upon hearing that his mom had suffered a stroke, and he indicated that he needed to travel to her and assist her and take care of her. He received a month leave that was approved by his supervisor. He indicated he would be back on a certain day. And there was some back and forth at the trial level as to whether the employer had made the decision as of the day that Mr. Monterosso was supposed to be back from his leave, or they made the decision a different day. There was inconsistent evidence on that issue. Nonetheless, it's clear that Mr. Monterosso was fired approximately 1 week after he indicated that he would be back under citing job abandonment. The employer had a 3-day policy that if you didn't come to work for 3 days, you were deemed to have abandoned your job, and he was found to be AWOL. One of the things that I thought was really interesting in this case is that the jury had awarded $1.29 million for the CFRA and the associational claim, and the court had awarded $625,000 in attorney's fees. So both parties had appealed. The defendant had appealed on the basis that the amount was not supported by substantial evidence, that there was no associational disability claim, and also complained about the fee award. The plaintiff raised the issue that they didn't receive a multiplier enhancement. The Court of Appeals held that on an unpublished case, that there was no duty under the associational disability claim. And so while there was no duty on that claim, the court did uphold the CFRA under the substantial evidence framework. And so the plaintiff did retain his $1.29 million verdict and retained his $625,000 in attorney's fees. So while this didn't go perhaps the way legally that on the plaintiff's bar, we would hope, it is, I think, a lesson that these cases, you're going to be bringing CIFRA claims, retaliation claims, disability claims, failure to prevent claims, for example, and these are overlapping claims and must be understood as such. So even where one of those claims under the exact same facts may not ultimately be successful, you can have seven-figure verdicts in these types of cases, and that's something that employers should be aware of when they're denying the sort of leave for an employee who's taking care of their sick mother.
All right. And then we come to the one case that is actually published in this entire series of cases. But of course, it is only a district court opinion. This is the McVeigh versus DXP Enterprises case. What we have here is an employee who was terminated after requesting leave to attend to his children who have serious respiratory illnesses. The employee brought several claims, and the defendant filed a motion to dismiss, a 12B6 motion, and specifically argued that the FEHA does not create a duty to engage in interactive process or accommodate for associational disability claims. This court had a really interesting opinion and way of getting to its decision from my perspective. It started by saying, because there is no published California precedential opinion on this matter, because Castro Ramirez is not actually a precedential opinion as far as the question goes, the court just noted that its job was to try to make its, quote, best prediction of how the California Supreme Court would decide the issue. And in doing so, because there's no precedential decision, the court is entitled to, and under other precedent, consider or look to, quote, well-considered dicta, unquote. Now, that's a phrase, before I read this case, I was not familiar with. I mean, I'm not an appellate lawyer, I'm not an appellate specialist, but that certainly is a concept I've never heard of before. The McVeigh judge cites a 1980 Ninth Circuit case for the proposition. Interesting, I thought. In any event, and also noted that a federal court sitting in diversity jurisdiction may not summarily disregard a court of appeal decision from California, from a state court, just because it's unpublished. And so may look to those types of decisions for what it's engaging in this exercise of trying to make its best prediction of what the California Supreme Court would do. And to get to its answer, the McVeigh court determined that the dicta in Castro Ramirez was persuasive, and particularly in the finding that under the Castro Ramirez reasoning, that the associational disability definition in 129260 meant that a person who is associated, an employee who is associated with a person with a disability, that disability is itself a disability in regard to the employee. It also noted again the structural differences between the ADA and FEHA. Interesting to me also is that the McVeigh court relied on Castro Ramirez, but there's no mention of the Monterosso case. The Monterosso case was decided several months prior. And as the McVeigh court noted, they weren't supposed to really summarily disregard the opinion just because it's unpublished. So it's an interesting question as to why the Monterosso case was not analyzed or discussed by McVeigh. Obviously, maybe the parties didn't bring it up. Maybe nobody saw it. Who knows? Just an interesting side note from my perspective. And then in the end, something we'll talk about later, the concept is one of the things the employer was arguing was they had, quote, pragmatic concerns about what would happen if, in fact, the court determined that there was a duty under these situations. and insofar as who are they supposed to communicate with when it's not the employee who has the disability, but the associated person, and several other kind of follow-up questions to that. The court brushed those concerns aside, saying, you're in the wrong forum. You got to go to the legislature if you got problems with that, not me.
Right.
So then we get to the next case, which is the Shaheen versus Kaiser case. Now, here we go again. We've got another California Court of Appeal case that's, again, unpublished. And in this case, what we have is an employee who, for years, many years, worked remotely, what they called telework in this situation. It's important to note this is all pre-COVID, all of the facts in this case. So the language that they use and things, even though the opinion came out after COVID, the underlying facts all took place prior to COVID. So there's some different concepts than maybe we would consider kind of more normalized now. Over the 10-year period where the employee, more than 10-year period, where the employee worked remotely 3 days a week and in person 2 days a week, which allowed her to care for her son or provide care for her son who had autism. She was promoted twice. There was no issue with performance again. And then here we go again. We've got a new supervisor coming into the picture. They're not happy with the situation of the remote work. And the stated reason for why the supervisor did not like the remote work was because the employee was now a manager, and the supervisor, quote, did not believe managers should telecommute because they should be visible in the workplace each day to respond to staff needs and ensure the fulfillment of productivity expectations. Now, side note, query, does a supervisor's, quote, belief meet the standard of an essential job function? Good question. I don't know. I know the arguments on both sides of that. I think things have changed since COVID on that question. But it's an interesting question.
I'd like to see an updated duty statement, Noah.
I'm sure you would. But that was what happened. And the the plaintiffs decided that this was not something that was sustainable. And then for both her own, she also got diagnosed and had some issues of her own that were disability related. And so ended up taking a leave of absence. And then and continued to request the remote work accommodation while on the leave of absence. It continued to be rejected, and while she was on leave, filed a lawsuit, which included failure to accommodate claims for the associational disability as well as her own. And again, the Shaheen court followed essentially the identical theory and reasoning of the Monterosso court and determined that the definition in 129260 only applied in 12940, where in 12940 it also the subdivisions also listed the multiple characteristics. So specifically, 12940 A, B, C, and D, as well as J1, each of those provisions in 12940 contain the multiple characteristic listing. But then if you look at 12940 M and N, they only use the singular characteristic, physical or mental disability, as opposed to the entire multiple characteristic definition or language that's in 12926. Therefore, this court, as well as Monterosso, determined that the intent of the legislature was not incorporate the associational duty into the accommodation and interactive process provisions. And part of what they did in reaching that decision is rely on AB 1670, which was the 1999 legislation that first brought the associational language into the FEHA, And they pulled a sentence out of the Judiciary Committee analysis on that bill, which said, quote, whether the purpose of this amendment was, quote, whether FEHA should be amended to strengthen discrimination protections or clarify ambiguities in the law. And just by that use of discrimination and not using accommodation and interactive process, the theory would go that the legislative intent did not cover those other sides. Now, they did not address the 2000 legislative amendments in AB 2222, the POP Inc. Act, that greatly expanded the overall language of the disability provisions of FEHA. But and then in particular, in regard to Castro Ramirez and the holding or the discussion in Castro Ramirez, the Shaheen court said it's dicta and, quote, we disagree, unquote, as to their outcome.
All right. So we didn't really hear much about this issue after that smattering of cases, which, not that I'm keeping score, but I think it was 2-2, right? Noah, two saying duty, two saying no duty. But it's quiet for a little bit.
At least two of them were decided correctly.
Right. But then last year, 2025, all of a sudden the issue comes back up again. So we start the unpublished trilogy. So we'll start with Acosta versus NAS Insurance Services. This is, again, a motion to dismiss case. So as much as I wish I had very detailed facts for you, I don't have a lot. It's a pretty short opinion. But we have an employee who requested a reduced hours, flexible work schedule, and a fully remote schedule to allow her to care for her child who had severe developmental delays. The employer refused, noting that the accommodation requirement just does not extend to an employee's dependent. And here, this federal court, again, in an unpublished decision, said that the FEHA permits accommodation claims based on association and therefore denied the motion to dismiss. The case referred to the McVeigh decision that we just talked about. Also, curiously, didn't refer to the decisions that came out the other way out of California appellate courts. And there we are.
All right. And then the next, so the next of this trilogy is the Head versus Costco case. And this was decided by Judge Ed Chen in the Northern District. And those who are familiar with practicing in his court know that his opinions often become very long and detailed, and this is no exception. This is a scenario where the employee, 30-year sales employee at Costco, had taken multiple leaves over the years, both for his own disabilities and for his wife's, to care for his wife who had cancer in multiple bouts of cancer. And in the end, the employer denied his final request for some additional leave because, as the employers said, the FMLA and CFRA banks, leave banks had been exhausted, and there was no obligation to provide accommodation for the associational disability of regarding his wife. So this court went through a very lengthy analysis because the Costco, the defendant, specifically argued on summary judgment that there is no duty to accommodate in these situations. And the court went through a very long analysis and included very long excerpts from Castro Ramirez, from Acosta, which we just spoke about, and from Shaheen and Monteroso, and concluded that there was a viable claim for accommodation in the associational disability scenario, and specifically held that the Castro Ramirez and its progeny were more persuasive than Shaheen and Monteroso in this regard. And it did so in reaching that conclusion. It was based on 4 reasons. And these 4 reasons that are listed here, starting again with what we were talking about previously with the statutory structure of 12926, that states that the preamble of 12926 states that all definitions are to apply in all instances where the defined terms appear within the statute, and that all definitions are to be used, quote, unless a different meaning clearly appears from the context, and that's in 12926. And secondly, or thirdly, I should say, the single characteristic definition of mental and physical disability that's within 12926 does not use the word association, but are written to be non-exclusive. And so that allows for the expansion and the expanded definition that includes 12926-0. And then finally, that FEHA is a remedial statute intended to be construed liberally and in line with that public policy that's provided within the statute in 12920 and other places, that in fact, this is the correct conclusion in the decision, in the opinion of Judge Chen.
The next one was the DeWitt case versus Amazon.com Services LLC. And I note that there was a different Amazon case about the exact same leave policy that I think got some action in the last 2 days. So if you want to look at what that looks like, where an individual claim was allowed to proceed, but the class claim was not. But for this particular Amazon case, the DeWitt case, the court, in an unpublished case, this is again the Central District of California, found that there was an associational disability claim that could be asserted. However, that in this particular case, the plaintiff lost at summary judgment. One of the things that I thought was very interesting about this case is here the employer had approved leave, intermittent leave, in order to care for a mother who had dementia and also for a child with a disability. However, Amazon has a very particular leave policy and allowed only the leave policy that was in the leave banks. So if the employee had time on their leave bank, then they were allowed the intermittent leave. If they didn't, then they were not. The employee ultimately exceeded the amount of leave in their bank and was fired. Where I found this a puzzling case is that an employer's internal policies regarding leaves don't thwart the duties under the Fair Employment and Housing Act or the ADA. So I found the result in this puzzling, although, of course, that the fact that there is an associational disability claim I thought was well considered.
All right. So now what?
Now what? Good question. We start with back in 2020, what was then known as the Fair Employment and Housing Council did something on that, as far as I was aware, is unprecedented. And for those who are unaware, I worked on regulations on behalf of the California Employment Lawyers Association for a good 13 plus years or so, diving deeply into all of the massive overhaul of the FEHA employment regulations that took place over that period of time. And so I attended, probably dozens of meetings and testified dozens of times and presented all kinds of written comments on proposed regulations. And in none of that time was there ever this thing called a request for public input, except this time in 2020, where the council issued this request regarding reasonable accommodations for associational disabilities under the Fair Employment and Housing Act, and posed the primary question that we've been talking about today, namely, is there a duty? And then asked several follow-up questions that would, assuming that the answer to question number one is yes, meaning that there is a duty, here's some sub-questions and follow-up questions. Now, the council received more than dozens of written responses, detailed written responses to this request, representing more than 50 stakeholder organizations. which is an unprecedented amount of participation and involvement in regulations, these FEHA regulations, at least from my experience. But despite all that, the issue died and it never resulted in any rulemaking. There was never any public explanation as to why, but this is where we are. But we thought it would be interesting as part of our discussion to go through some of those follow-up questions. And so these are the questions. We've modified them slightly, but really these are the kind of practical implications of this. And starting with, should there be a limit on the types of relationships that would warrant an accommodation for an associational disability? And Katie, why don't you take a crack at that?
Yeah, so, of course, assuming a duty exists without conceding one does, but for purposes of these questions, we'll assume that. I think there have to be some clear limiting principles, right? This concept of associated with is really broad, and the FEHA does not provide us with any guidance about what relationships would qualify. And I think the broader a duty becomes, the more difficult it is for an employer to administer it consistently. And we want employers to be able to enforce policies consistently, and I get a little worried about the idea of employers making subjective judgments about the significance of personal relationships. So absolutely, some guidance would be very helpful about what types of relationships would in fact qualify.
Not surprising, I have a different take on it. I think where courts may look is what has happened in cases looking at associational discrimination, meaning what sort of relationships were considered viable for those claims. So not in the accommodation context, but in the discrimination context. And if we look at those cases, there have been found father-in-laws qualified, co-workers qualified, and friends qualified. So I think if a court is looking for what has happened in cases looking at this issue of association previously, then there was not a limit solely to, for example, the relationships that were in the CIFRA or FEMLA. Additionally, if we look at where legislation has been going, and I know this is a legislative issue as opposed to what exists already within the statute, there has been an opening up under CIFRA for a designated person, for example, and the concept of chosen family. The family structure is not these days solely the nuclear family, but rather the concept of chosen family is a lot more accepted and reflects the realities of Californians and how they construct their families. And so further, nothing in the statute has limiting language. So if a court is going to read in limiting language, they would be writing that in whole cloth. So I don't think the statute currently would support such limiting language. We may see legislative changes on this, and I could make predictions as to how that would look. Looking at CIFRA and the expansion and limitation of certain of those relationships. Because as it stands in the statute today, there is no such limitation.
So the next question that the council asked is would the employer be permitted to ask for proof that the person requesting the accommodation does in fact have a qualifying association with the person with the disability, and kind of, if so, what does that look like? Wendy, why don't you start with that one?
I do think an employer can ask for a certain level of proof. I think where the rubber hits the road is how much proof and what's the type of proof. If we look to Cal Government Code section 12945.2, for example, that would allow a certification which indicates the nature of the accommodation needed. It would allow for a healthcare certification like CIFRA allows for. I think where it's going to get a lot more problematic is if the employer is asking for the third party's medical records or wants to do some sort of medical examination. I don't think that's going to be allowed. And I think that a certification such that's already permitted under law is where it's going to be headed.
And Katie?
I agree with Wendy. I think some certification would make sense. I think that is consistent with how we treat other things in the interactive process and reasonable accommodation space. Although we certainly encourage employers and employees to talk to each other, communicate, try and figure this out, there is a bit of a trust but verify undertone, right? Where, your employee can tell you the accommodations they need and the restrictions they have, but when reasonable, it's okay for the employer to ask them to provide a medical certification to verify that there actually is a need for it. So I think if we're borrowing from that framework, it certainly would make sense to also require some kind of verification of, the relationship with the person who they're saying they need an accommodation for. I don't know what that proof looks like, though, right? I mean, are we asking for marriage certificates? I don't know.
Right.
What if we adopt the designated person designation, as Wendy argued with the last question, right? What does that look like? So, but yes, I think the concept of asking for verification would be consistent with how we handle other things.
And so really, Katie, I think the toughest part of this is how does the interactive process work in these associational accommodation scenarios, especially when we talk about medical documentation and privacy rights of the third party, the employer's obvious concerns about what documents they have, how to maintain them, how to make sure that they're not violating anybody's privacy rights or medical privacy rights or otherwise. So Katie, how would you expect that to be navigated?
I agree with you. I think that is one of the most challenging parts of this because traditionally when we think of the interactive process, it's designed to evaluate what are the employees' restrictions, what are their job duties, and what accommodations can we bring together to try and marry these two, right? Those things kind of go by the wayside when we're talking about caregiving, right? It's really more akin to a CFRA, certification of healthcare provider, right? Where, I have this family member, they have a disability, and therefore I need X. And I agree with you. I think as someone who represents employers and provides advice in this space all the time, employers should be really worried about what to do with private medical information that belongs to their employees' family members, right? They already don't want the private medical information involving their employees. So I think this is an area where some guidance would be helpful if this is the direction it's going.
And I don't think that it's all that different, honestly, because the types of accommodations for caregiving that are commonly seen, for example, is intermittent leave, working from home, scheduling adjustments, policy exemptions, for example, like being able to have a cell phone so you know if there's a medical emergency, or having a regular day off. That's not unusual, for example, for religious accommodations, for Sabbath observance. Often people have a designated day off, and that's one of the most simple accommodations that an employer can provide. So I think in the interactive process, it would look the same. What does the employee need? Maybe they need time off of work on a particular day to take their family member to chemotherapy. And that may be a few hours on one day a week or one day every couple of weeks. I think it looks the same as if the employee themselves needed that chemotherapy. I think it's the same type of interactive process. So I think that I understand the fear that employers may have that this opens things up, but I think on the ground, it's actually the same process that they should already be following as it relates to accommodations for employees' own disabilities.
So Katie, I think we've covered quite a bit of these. I think we can go ahead and skip off to the policy debate, as it were. If you want to go ahead with that.
There you go. All right. We are on the policy debate slide. Wendy?
Sure, I think that
I feel like this one's for you to start.
No, well, in terms of recognizing the duty, one, I think it's already the law. I think the Castro Ramirez hit the nail on the head. I think that this already exists under the FEHA. And the FEHA is broader in many respects than the ADA. It protects caregivers from discrimination. It reflects the modern caregiving realities. We saw this hugely when COVID happened, where a lot of employees needed, particularly statistically, women needed to take care of children or elders and their medical care in the workplace. And we all made it out okay with those caregiving realities and being able to perform their job duties. It's consistent with FEHA's remedial purpose, and it's consistent with the statutory construction. And I understand that this is for employers, but I think this is a really important point for employees. And employees who are provided with accommodations in the workplace, there are studies that demonstrate that they're more loyal, they're more likely to stay, and individuals who are provided with accommodations, they actually save money for employers. So I think if employers actually look at those statistics and think about whether they want a workplace that's employees who feel loyal and who will stay and not jump to other employers, they really should consider this duty and the modern realities that are happening in the California workplace.
Well, not surprisingly, I see things a little bit differently than Wendy on this point. But I do want to go back to something Wendy said earlier that I think really highlights one of my core issues with this. The language is drafted just says association with, associated with. There is no limiting principle, right? And when we compare that to other laws that address caregiving, like the CFRA or paid sick leave, we do have some definitions up about what types of family relationships qualify and things like that. So I think California law does contemplate guardrails and limiting principles around caregiving responsibilities. So without some kind of change to make that match, I think this potentially, could really balloon and expand accommodation obligations dramatically for employers. And, in a way that before Castro Ramirez, we all kind of accepted wasn't required, right? And now for the past decade, we've been arguing about it. And again, California has lots of leave laws and accommodations and things in place for caregivers. We have lots of options available to caregivers that address a lot of needs. So with that, looks like we're a little over, but we want to leave you with some practice tips. So from the employer perspective, I would recommend that you carefully analyze requests tied to caregiving responsibilities and always consider whether a request can or should be addressed through FMLA, CFRA, or your existing leave policies. Like Wendy very astutely pointed out and gave a big old warning to any employer representatives on this call, right? You may ultimately win the question on associational discrimination, but lose on a CFRA or FMLA claim, right? So make sure when you're getting requests in, you're looking at FMLA, CFRA, or if your client has a broader leave policy. Lots of clients go above and beyond what FMLA and CFRA provide. Lots of employers do. So certainly take a look at that. Consider consistency with remote work and flexible scheduling policies and practices. As Noah mentioned, the landscape has changed quite a bit since COVID, right? A lot of that case law that we talked about, the facts predate COVID, when people weren't working remotely as much. Now, a lot of employers have certainly expanded their minds and options when it comes to remote work. This is really important. I think document your interactive process efforts, even if the legal duty is unclear. Now that we have a growing pile of unpublished cases that tell us how unsettled this is, you should engage in the interactive process and document those efforts. That would be a very advisable thing to do because we simply don't know which case is going to ultimately become published and answer the question. And then, of course, be cautious about perceived retaliation if someone makes a request. And, even if ultimately there is no duty, that could still be a protected activity anyway if they believed in good faith that they were making a legitimate request. So always be cautious about perceived retaliation. Another one of Wendy's favorite claims, I'm sure.
Exactly right. In terms of employee takeaways, one of the things it's really important to frame your request clearly and specifically. If you say, I want off from work early because somebody's sick, eesh, that's not going to be as strong to say, I need off from work at 3 o'clock because my spouse needs to attend chemotherapy and it's of 2 hour duration. The second request is far more likely to be successful, both without needing litigation. But if you unfortunately find yourself in litigation, that's going to be a much more winning request in front of a jury. Tie the request to concrete workplace modifications. So, for example, if you need one intermittent leave, be very specific. If you need to have your cell phone, but the policy says you can't have a cell phone, be very specific. So tie it to specific workplace modifications. If other people are allowed flexibility and you're not, let's say to take care of a child who has a disability, but somebody else can take off to do their bowling league or some other issue like that, preserve that evidence that individuals with disabilities are being treated differently, or those that associate with those with disabilities are being treated differently. You would have probably a viable discrimination association claim, even if there's no reasonable accommodation claim. Expect disputes over documentation and scope. So this is the question of what do you need to show if you say that I have a person I need an accommodation for to assist with caregiving. Maybe talk to that person to say, look, I'd love to take care of you, but this may mean I need to provide some information about your medical situation. Because I do think the employer is going to ask for some proof and verification, and it's good to consider that up front internally with your family member or the person you're helping with. In terms of looking at the full picture, though, I think any person representing workers needs to assert multiple causes of action. So I would consider the associational discrimination claim as well as the accommodation claim. And as Katie very specifically and astutely indicated, retaliation claims, because if you ask for an accommodation, that is a protected activity. And even if you're wrong, if you thought that it was protected and you're retaliated, for example, you're terminated as a result, then that is a viable claim. So when you're considering these claims, I would be looking at CIFRA, FEMLA, discrimination, associational discrimination, retaliation claims, as well as accommodation claims, because one of them is likely to get past summary judgment and onto trial.
And I'll add that, when I'm looking at these cases from a neutral perspective, and I'm looking at, imagine a mediation where these claims are central, and we have this type of history with the cases and unsettled area in particular. What I'm looking at is risk, right? Risk on both sides of the equation here. And if you've got an employer who's arguing and making a case, especially in mediation, that they're going to win summary judgment, there is not going to be any cause of action for the accommodation, the associational accommodation claim, and that's either primary claim or the exclusive claim. That's a pretty risky position given the status of the current case law. I would argue to them. On the other side of the equation, and I'm talking to plaintiffs' counsel, it's still a significant risk because you do have, the dynamic here is so interesting because we have a flip of the normal dynamic between the federal courts and the state courts when it comes to interpreting California state law. Typically, what we see is the federal courts are more restrictive in their analysis of in respect to employee coverage and expansion of rights for employees. The federal courts have traditionally been a bit more restrictive in those analyses when there's an open question than the state courts. And often you see cases go all the way up to the California Supreme Court, especially in the labor code provisions, where they are correcting, so to speak, the federal court's interpretation. This time you've got the reverse. You've got two Court of Appeal unpublished decisions that say there's no, it's a more restrictive analysis under the statutory definitions. So if I'm talking to the plaintiff's counsel and talking to plaintiffs in their room in a mediation, this is an interesting dynamic, and there's no clear outcome at this point. So you're each weighing really significant risks, which means this is a great case to settle, right? And so that's, to me, the definition of a great case to settle, because nobody really knows the outcome. And if you're banking on a summary judgment outcome, that means that it's kind of a bet the case motion on one hand or the other. And as Wendy described from the Monterosso outcome, those are significant verdicts, even though in that case, it wasn't an associational claim, but it was a CIFRA claim. But still, these cases, when you just read the facts, are, I would argue, pretty sympathetic in the fact of the case. Forget about legal technicalities and legal rights. To me, these are things that juries can identify with and latch on to, because they are talking about primarily family caregiving scenarios, close association, primarily family members, but others who may be included, and providing care for them, providing kidney dialysis for your son, providing palliative care for your wife who's undergone multiple bouts of cancer. Those are claims, I think Wendy would agree, that a plaintiff's attorney would be very eager to bring before a jury. So these cases are really, really interesting and tricky. And when you're trying to resolve them, you really have to consider all of these risks. And it's just, it's just a very interesting, from an intellectual point of view, scenario and how it plays out in any particular situation. Now, we do have a couple of questions in the question and answer segment, if we want to look at those. The first question, we're going to stick around for folks who are out there. I think we're going to stick around for as long as people want to ask questions. So feel free to keep dialing those into the Q&A box. The first one is, would it benefit the associated person to be listed as an in-home helper? Any thoughts on that?
I mean, I don't really see that as a determinative fact myself. I think you'd be looking at the totality of the circumstances. If you're the only one who can take care of, for example, in the case where the only one to take care of the child who needed dialysis, I think that is a fact that at least a jury, if it gets to a jury, is going to be looking at very closely. But I haven't seen any case where they took that particular factor into account.
Katie, any additional thoughts on that?
Yeah. No, I agree with Wendy there. Ooh, but I'm curious about everyone's thoughts on this next question.
Okay, so the next question is, can the denial of the employee's request for an associated reasonable accommodation itself be considered retaliation?
I think the answer is yes, because asking for an accommodation is a protected activity. And for the case law regarding retaliation claims, is you can be wrong on your underlying complaint. So for example, taking a more traditional complaint, you could be wrong about being subject to discrimination or harassment in the workplace, meaning that you could lose those claims and still have a viable retaliation claim. I think the same is true here. So long as the employee had a good faith, reasonable basis to believe that that was covered. And clearly, there's a good faith, I think, given that even the courts can't seem to agree. I can appreciate how employees would think it was covered, that I do think it's a protected activity. And if the employer were to take an adverse employment action against the employee, I think that's cognizable. Further, for retaliation complaints, the definition of an adverse employment action looks at the totality of the circumstances, and it's broad. It's not just ultimate employment actions. And so I think the employers out there need to also consider that.
not surprising, I'm going to take a somewhat different view than Wendy here. I think, although I do agree with Wendy, certainly the request itself, I'm not going to argue with Wendy. Requesting the accommodation is certainly a protected activity. I don't know if I feel as strongly, though, that a denial in and of itself is the adverse employment action, right? I mean, I agree with Wendy that it certainly doesn't have to be something as extreme as a termination, right? But typically when we think about denial of a request, what claim flows from that? That claim is typically failure to accommodate, right? That to me is the legal claim that flows from denying the request versus that being a form of retaliation. Now, do I think that an employer needs to be very careful after denying someone's request for legitimate business reasons? Should they be very, very careful about everything that happens afterwards? Because certainly the employee is going to be on high alert after they've talked with Wendy. They're going to be on high alert for potential retaliation. Yes. But I don't think a denial in and of itself is the adverse employment action.
Yeah, it's tricky, isn't it? Because, there is case law. Wendy, correct me if I'm wrong, but I think there's case law that says that a denial of accommodation is not an adverse action under a discrimination claim. It's a failure to accommodate, and you can't graft the failure to accommodate into a discrimination claim per se, as that's the actual, using that same kind of theory. I mean, there's some parsing of language and of actions in those cases, but I think the theory has been rejected, at least in ADA cases, that say that that's not itself an adverse action that supports a discrimination claim. It supports a failure to accommodate claim potentially, but not the adverse action claim.
I think this is one where we're going to see cases where the facts are going to drive the results. So, for example, if you have someone who in these cases, they're a long-term employee, they've been allowed to provide these caregiving, say, intermittent leave for the last 10 years. Suddenly you get a new boss who's perhaps not the nicest person, comes off pretty horribly in light of the long-term employee who's been able to do a fantastic job with those accommodations. Suddenly they're requesting the intermittent leave, and that's taken away from them. And perhaps other comments or actions happen. I think that's going to be a good case to test this. Whereas I think if you don't have that sort of change, that's going to be a harder road on the worker advocate side.
Well, that's all the questions we have in our Q&A.
It is. Well, thank you, everyone. And thank you, Noah and Wendy, for talking about this fun subject with me.
Always such a pleasure.
It is great.
You are my favorite defense attorney, Katie.
This allows us to really geek out on some really interesting areas of law. Those of us who practice in disability discrimination law or have practiced in disability discrimination law, which I did for 28 years. It's really just a great topic, and it's so much fun to talk about with both of you.
Thank you. Thank you, Noah.
Thank you, everyone, for joining us. Have a wonderful evening.